Hello everyone, my name is Vaishnavi Parate. I am a law student and today we are going to discuss and learn about what are the general exceptions under the IPC. So let's start. Let's start with the introduction. The criminal law covers various punishments which vary from case to case, but it is not always necessary that a person gets punished for a crime which he or she had committed. The Indian Penal Code 1860 recognizes defences in Chapter 4 under general exceptions. Section 76 to 106 covers these defences which are based on the presumption that a person is not liable for the crime committed. These defences depend upon the circumstances prevailing then, the mens rea of the person and the reasonability of action of that accused. Before heading towards the general exceptions, let's see the objectives behind the Chapter 4 of IPC. Every offence is not absolute, they have certain exceptions. When IPC was drafted, it was assumed that there were no exceptions in criminal cases, which were a major loophole. So, a separate Chapter 4 was introduced by the makers of the code applicable to the entire concept. In short, the object of Chapter 4 includes exceptional circumstances in which an individual can escape liability, making code construction simpler by removing the repetition of criminal exceptions. Let's see, in such a situation, on whom the burden of proof lies. Generally, prosecution has to prove its case beyond reasonable doubt against the accused. Before the enforcement of the Indian Evidence Act 1882, the prosecution had to prove that the case does not fall under any exception, but Section 105 of the Evidence Act shifted the burden on the claimant. Now let's see what are the general exceptions one by one. First, mistake of facts. Section 76. Act is done by a person bound or by mistake of fact, believing himself to be bound by law is included. Nothing is an offence which is done by a person who is or because of a mistake of fact, not by mistake of law, in good faith believes himself to be bound by law to do such act. Section 79. Act done by a person justified or by mistake of fact, believing himself justified by law is included. Nothing is an offence which is done by any person who is justified by law or who by reason of mistake of fact and not mistake of law in good faith believes himself to be justified by law in doing that particular act. Now let's see the second exception, judicial acts. Section 77. Act of judge when acting judicially. Nothing is an offence which is done by a judge when acting judicially in the exercise of any power which is or which in good faith he believes to be given to him by law. Section 78. An act done under the judgment or order of a court of justice when the person doing the act in good faith believes that the court has jurisdiction is no offence. Now let's see the third exception, accident. Accident is a word which is used to indicate a course of events or acts done by a person over which he or she had no control and was unavoidable after taking due diligence and care. Misfortune is a sign of bad luck or an undesirable event. Section 80 of IPC immunes a person who does an act innocently and lawfully and without any mens rea for committing an offence. A law provides that a person cannot be punished for an act over which he had no control and the consequences were not probable. Here is the fourth exception, necessity. The term necessity is defined in Black Law's dictionary as a controlling force, irresistible compulsion, a power or impulse so great that it admits no choice of conduct. Section 81 provides for the defense of necessity, which means that an act which is done might be a crime if it was done only in order to avoid consequences which could have inflicted more harm to the person or property. Now let's see the fifth exception, infancy. The defense of infancy can be taken when the act is done by an infant who is under 7 years of age. By presumption of law, an infant under the age of 7 is considered to be doli in capex, which means that the child cannot constitute the required mens rea to commit a crime, whereas an infant of 7 or more is considered to be dolix capex, which means that although the child is unknown to the crime or can frame intended mens rea to commit the crime. Now let's see sixth exception, insanity. Section 84 of the IPC provides for a defense to a crime committed who are insane or who cannot constitute required mens rea to commit an offense. Every normal and sane human being is expected to possess some degree of reason to be responsible for his or her conduct and acts unless any contrary is proved. But a person of unsound mind or a person suffering from a mental disorder cannot be said to possess this basic norm of human behavior. Here is the seventh exception, intoxication. Intoxication is a state of mind in which the person is incapable of knowing the nature of the act, or he was doing an act which was either wrong or contrary to law. Section 85 and 86 provides immunity to an intoxicated person only if the intoxicating thing was given to him without his knowledge or against his will. Here is the last exception, trivial acts. Offences by trivial acts are those offences which cause slight harm which would not be complained by an ordinary person. Section 95 of the IPC provides immunity to the person who commits trivial offences. A trivial act is distinguished depending upon the nature of the injury, the knowledge, intention, and other related circumstances. Therefore, if the allegation of the complainant is of a petty or trivial nature, then no criminal proceeding should be taken.